So you want to pass that real estate exam. So how are you going to do it? By watching this and preparing with real estate questions for national and then for Texas. So get ready for a great evening of prepping and take that exam. Whatever state you're in, take that exam. And for those of you that are in Texas, you'll practice the national and then Texas questions. All right. So we're going to continue on where we left off on Monday. And the section on where we start is actually in the description below. So I consecutively go through with the questions on the book that we are using that's been approved by the author, the Metling father and son team. Okay, and for anyone watching the replay, the class is designed to let students prepare during the session and write in their answers and I help them to understand the question. So, hey, just fast forward if you want to wait and you want to see the final answer for each question through the discussion. And for anyone that this is your first time here, hey, remember to tap that subscribe button for YouTube Agent Prep with Wild Lillie Handy. Like this video and click this bell, the little bell, should you find this video useful. Okay, well, I guess I need to share my screen. So here we go. All right, we are starting today with, test number 2 on the national exam, encumbrances, liens, title transfers, and recordings. So remember to type your question, the question number and the letter answer when you're participating. And hey, participate. This is to help you prepare for the exam. And where else best to participate and find out whether your answer is right or incorrect. And if it's incorrect, I'll help you to understand it and explain why. So do it here. Take that risk. Oh, I meant to turn the radio off, or not the radio. Pandora, because last time it came through and it showed up on the video and YouTube didn't allow to monetize the video. Okay, and you're probably wondering, what the heck is monetize? Well, after you reach 1,000 subscribers and 4,000 watch hours, YouTube can start paying us for you watching. So that's why I ask you to watch on YouTube versus Facebook, even though you can watch it in either place. All right, so number 1, which of the following best describes an encumbrance? So what is an encumbrance? Okay, that's vocabulary there. A third party's right to encroach upon a property without the permission of the property owner. B, a third party's right to claim the sale proceeds of a property that has been mortgaged as collateral for a loan. C, a third party's interest in a real property that limits the interest of the freehold property owner. Or D, another's right to acquire a freehold interest in a property against the property owner's wishes. Gosh, I just realized I forgot to send a reminder. So while you're thinking of the answer, hi, Cindy, I'm going to do that so that everyone knows that we are doing class tonight. So go ahead and type your answer while I do this. I forgot to do it last Wednesday too. So type your answer in the chat. Anyone? Hi, Lena. Hi, Cindy. Hi, Sophia. That's so good. And okay, Sophia says C so far. Anyone else? So I'll give you a little bit more time since many of you are just coming on. So anybody that just came on, we are doing national questions that apply to all states. All right, let me see here. Where were we before? So bear with me a moment here. We're on test number 2. Okay, let's see what answers we've got. We've got C, Hi Delta, C, and B. Okay. A little disorganized today. Busy day. Okay, so A, we got C, C, C. Yes, and the answer is C. A third party's interest in a real property that limits the interest of the freehold property's owner. So it could be a lien, it could be, that's a third party's interest. It could be the lender, okay, that has a lien on the property. So that is an encumbrance. Could be an easement, okay, something else. However, when it says a third party's interest, that could be a lender. And if there's a well easement, septic easement, a road easement, those are attached to the property. So if they're recorded, okay, that's a good thing. But if they're holding the property and preventing it from being sold, which is why it says interest of the freehold property owner. Freehold is like they've got all the bundle of rights. So an encumbrance will limit that fee simple or bundle of rights ownership. So very good for those of you that answered C. Now B says a third party's right to claim the sale proceeds of a property that has been mortgaged. No, it's not dealing with sale proceeds. Okay, it's dealing more with a lien being on the property that shows up on the warranty deed, okay, on the title, and it'll prevent it from being sold, except if it's going to be paid at the time that it gets sold. So that's why it's not B. It has nothing to do with the right to claim the sales proceeds. Although if the lender forecloses, right, they'll claim the proceeds. However, anything above the loan amount, that difference would go to the property if it were to get foreclosed. And hopefully we'll have a good signal today, as I think on Monday we had terrible signals. Okay, so let me type the answer on Facebook, as I am streaming both to Facebook and to YouTube. All right, number 2. Which is the true of easement in general? Okay, general is broad, remember? So which is true of easements? So what is an easement? If you're not familiar with what an easement is, then vocabulary. Same with encumbrance. Real property, freehold interest, freehold property owner. all those are vocabulary. So you can tell a lot of vocabulary in questions and the answers. Okay, so which of the following is true of easements in general? They involve the property that contains the easement and a non-owning party. B, they apply to a property, whole property, the entire property, right? When you have a use of a property, when you own it, you have possession and use of the whole property, not to any specific portion of the property. C, they only involve a legal owner of the property. Or D, they may require specific use, but cannot prohibit one. So what is true of easements? So you could have a road easement, you could have a well easement, a river access easement, a creek. Cap is making me itch. So I'm going hatless today again. You can an easement to access a pond, to access the creek, the river by this property, and all those easements more than likely are recorded. What is the true statement of easements? Okay, so far we've got A. Can I make it larger? I will attempt that. Are you watching on your cell phone? That's usually when I do that. Okay, can you see it now? Who is that? Lisbeth. Hey, how you doing? All right, so it's larger there. Type your answer in the chat. Okay, so we've got A. Hey, don't apologize, Lisbeth. So you're driving. Just be careful. So you're going to be listening, right? Okay. What happens if an easement is unrecorded? I'll answer that in a little bit. Okay, so we've got lots of A, so that's good. Now we have a D. No, the answer is actually A. So which of the following is true of easements in general? A, they involve the property that contains the easement and a non-owning party, right? So you have the dominant and the servant party. So the dominant is the one that is the non-owning party. They are using the easement. The servant party is the owner of the easement. So the answer here is A. So I'll get to your answer in just a moment, Delta. It says they may require a specific use, but cannot prohibit one. No, they can prohibit, if it's an unrecorded easement, okay, they can't. So it depends on the use. Okay, so they can prohibit an easement and they can allow it to a particular person. And when the property is sold or that power, so let me put this question up there. When the property is sold, an unrecorded easement does not go with the land. So it was an easement just for that particular person or family to use it while they owned it. So that does not go with the land. When an easement is recorded, it goes with the land when it is sold or bought by somebody else. So what happens if an easement is unrecorded? It goes away if the owner, the person using it, is no longer accessing it, or the owner of the easement sells the property. Then it goes away when it's not recorded. So whenever, for some reason, a lot of times these easements happen, out in the country. However, there are also some city areas where if you have a flag lot or somebody needs to access the lot behind theirs and there's no way to get into it, so they create a driveway easement because that would be the only way to get to the lot behind it if there's no access from that parcel. So something like that would be recorded. Okay, very good. Number 3. Here, I'll make it a little bit larger so that Miss Lisbeth can see it. So that's for when you're on your phone, right? You can be able to see it. Should any of you be seeing this and the resolution is poor, that means it's blurry, the setting is actually on your computer. And it would be, let's say you're watching on YouTube, all right? Then to improve the appearance of the screen, well, as soon as this enlarges, I can show you, okay? You see this little gear down here, the setting. You would go to the settings and you see the quality here. Actually, my quality is not the best, so that's for me to view it, okay? Not for you. So on your computer, you can adjust that on Facebook and also on YouTube so that you select the 720 resolution is the best one. Some of you might have 4K, but you usually see 720 is the maximum. Then you'll be able to see a clear picture. Okay, let me, because I have 3 monitors here. That's why you see my face going from left to right or up or down, okay? Because I'm looking at multiple screens. And you know what? I don't think I showed the answer for A. So A, it was not, 2.1. The answer for 2.1 was C, and the answer for 2.2 is A. Okay. All right. Number 3. Mr. King wants to offer 100 acres of his property for sale. Since the property is landlocked, so that's kind of an example that I just gave you about having to have an easement because a front lot may not give access to a back lot. That's what landlocked is. Since the property is landlocked, he will have to put in a driveway to the road that will run across his remaining property. What kind of easement will he have to grant? A, an easement in gross, B, a commercial easement, C, a personal easement, or D, an easement appurtenant. See, I think in one of the other classes, somebody mentioned that easements are an encumbrance. They are attached to the property. They're also called appurtenant. Okay, Miss Sophia answered D. Hey, Miss Cindy, I would choose another answer. Lena says D. Lena Tooable or Lena Too-able? So type your answer in the chat. So what is an easement? It's not A, an easement in gross. So that is vocabulary. So an easement in growth, is it frozen? No, it's not frozen at my end. Maybe it froze at your end, not on here. So an easement in grows. Okay, let me show you here. An easement in grows, okay, is more of rights are personal rights that usually terminate upon the death of the individual owner. So it's an easement that's given to a property, or easement in gross also means the easement is owned by a business or entity. A common example of easement in gross in Texas are pipeline easements for oil and gas production. So in other ways, you come down, you look for another one. So for example, if your family owns land that abuts to a highway and a local dairy farm wants to access that highway by cutting through your land, your family may sell a commercial easement in gross to the dairy. So that's talking, predominantly on commercial easement, but it's an easement that is provided to a person. So then you keep looking. So a lot of the utilities, they're easement in gross, right? Because they have to have access, okay, to the utilities, the electricity, the phone lines, gas, water, sewer, and those go with the land, right? And those utilities have to have access. You can't say no. So let's see, what's another term for easement in gross? Such an easement may exist in perpetuity and be transferred when the property is sold, encumbering the new owner. An easement in gross, also known as a personal easement, attaches the right of use to a single individual or entity. So that's like your utility companies, right? And if that individual passes away, then that easement in gross ends, like it mentions in the first one. So rights of a easement in gross are personal rights. That person dies, then it ends. All righto. So you got that, Miss Cindy? And this one actually is an easement appurtenant, because what he's doing, so you have an example of a piece of land and they have to access another piece of land behind them. So the lot behind them or beside them is locked. There's no access to get to that land without using the current owner's driveway, but the driveway doesn't go all the way to that other piece of land. Therefore, the owner will create a driveway or extend the driveway in order to give access to that other owner. So this owner that owns the land becomes what? The servant party or the dominant party? So write in the chat, the person, the owner that owns the land, that owns the easement, what are they called? I just mentioned it a little bit ago. So type in there, the person that, or the whole property that owns the easement, what are they referred to? Are they dominant or servient? The property that owns the easement, they are the servient, as Lisbeth specifies here. The person or owners that are using it have the right to use it are the dominant. Okay, so we have the servient, that's the owner of the easement. Then we have the dominant, that's the person that uses the easement, or the owner of the land that uses the easement. So yes, Cindy, the owner is the servient. Okay, very good. So that was D, an easement appurtenant. So easement appurtenant, it's attached to the land, right? The appurtenant means it's attached to the land. So if you were not aware of those words, go back to the vocabulary, okay? And I'll keep stressing because vocabulary is very important. You're learning a new language. And one of the students that passed, he watched a lot of vocabulary videos and it helped them tremendously. He watched mine, maybe some others, and got to hear and listen. And so he practiced it. Yes, Sophia, the owner owns the easement. That is correct. All right, number 24, 2.4, pardon me. If property alpha has a court-ordered easement, okay, a court-ordered easement, property alpha, across property beta, in order for alpha to have access to a public road, the easement is A or N, an easement by prescription, B, personal easement, C, easement by necessity, or D, easement in gross. So it's court ordered. Those are key words. So property A has a court ordered easement across property B. In order for A to have access to public roads, the easement is easement by prescription, personal easement, easement by necessity, or easement in gross. Whoa, we've got all kinds of answers here. We've got A, B, and C, and I know my ABCs. And the answer is C, easement by necessity. It's court ordered. So it wasn't a recorded easement. Okay, so it's by necessity. So probably the court is forcing, okay, property B to record that easement so that, because it's by necessity in order to access public roads. Remember, personal easement and easement in gross are basically the same thing, just two ways of seeing it. All right. And so in this case, since the court ordered it, that means it's because it's a necessity to be able to use that easement to access the road. So the owner was probably denying that access because there wasn't a recorded easement. So when the court orders, then it becomes a required easement, and they will have to end up recording it so that it passes with the land whenever that property is sold. So easement by necessity arises when a grantor either conveys so let me show you this. So easement by necessity arises when a grantor, that's the owner, okay, either conveys, transfers, or retains a parcel of land that fails to expressly provide for a means of access. So they're showing this is an easement. So this is the property, and this is the easement. So in this situation, courts have made an assumption that the initial landowner had intended to so do and will imply an access easement. Oh, I'm sorry, that's easement by necessity. I was looking for easement by prescription. So that's what we just discussed. It was ordered by the court. So then prescriptive easement, the person claiming the easement must prove that he or she has used the easement for at least 10 years and the use of it. So that's almost like adverse possession of somebody wanting to take over a piece of land. So they have to prove that they've used it for a certain number of years consecutively. Each state is different. And then they would end up winning that piece of land. They would end up getting that piece of land because it was visual to everyone else. And so did the owner know, unless the owner was out of the area. And so it wasn't hidden. And if it's visible, then they could claim, hey, it's mine. I've been maintaining it and I want it. And the owner will actually lose it. Okay, so here it's in not getting the property, but this is just the use of the easement for at least 10 years. So open and notorious, right? So they're not a secret agent using the easement. It's open and notorious. It's continuing for 10 years. It's exclusive only to them. And it's adverse. It's against the owner's knowledge or will. So if the owner knew, then he would have to kick him out of there. But if the owner didn't do anything about it, then that individual can claim and have that easement recorded so they have access as long as they're there. And if it's recorded, so it could be an easement in gross, right? As long as they're alive and they're there using it, it would go from prescriptive easement to easement in gross because it would end up becoming for them. However, once they die or they leave, then that easement is no longer in existence. If it gets recorded, then it passes with the land. So it depends on how the easement is set up or how is it being used, whether it's a utility easement. If it's a utility easement, they have access at all times because they have to maintain the utilities, right? So that was an easement in gross for utilities. Okay, so 2 was by necessity. Anything different. So easement by necessity is an easement appurtenant. It's an easement attached to the piece of granted by a court of law. Okay, which that's the main key word there. Court ordered by a court of law to a property owner, which the property owner was beta, because of a circumstance of necessity. The necessity was to access the public road, most commonly the need for access to a property. Since property cannot be legally landlocked, like it was in the prior question, where they don't have access to it, or without legal access to a public thoroughway, a court will grant an owner of a landlocked property an easement by necessity over an adjoining property that has access to the thorough road. So whether the owner of the other property likes it or not, the court can order it because that's the only way that they're going to access a public road. Y'all get that? I mean, most of you got it right. So I would say go and review, all the different types of easement. So the utility easement in gross, right, is one of the the police powers, right? Has have access to it at all the time. All right, number 5. Well, that's not going to work. Come on, number 5. Go to the other side without causing me issues here. Gosh, I can't seem to get it all on one page there. There we go. Okay, 5. An encroachment is vocabulary, okay? A, an easement that has not been recorded on the title of the burdened property. B, an unauthorized physical intrusion of one property into another. C, a right granted by a property owner to the owner of an adjoining property to build a structure that protrudes across the property boundary. Or D, a structure that does not comply with the zoning ordinance. What is an encroachment? So far, we've got B. And for anyone who just came in the last few minutes, we are doing national questions that apply to all 50 states. B, that is correct. The answer is B, an unauthorized physical intrusion of one property into another. It could be a fence, it could be a shed, it could be a building, anything like that. And to find out for sure, right, they'll do a survey, right, which outlines the property corners and all the boundaries of that property. And should it be into the other person's property, okay, it'd be encroaching onto, let's say, your property, the other person encroaching on yours will have to remove it. However, you've got to make sure that they remove it. Because they may not want to remove it voluntarily, because when they bought it, they said, well, it was there already. You know, why should I have to move it? Well, you're actually on my piece of land, all right? Okay, it was B. Everybody got it right? Yes. All right, number 6. Gosh, look, now 2.5 comes out real big. Okay, number 6. A court might grant if a town needs to dig a trench across an owner's property to install a sewer line to a neighboring property and the owner refuses permission. B, a property owner sells the front half of a lot and wants to continue using the driveway to access the rear of the lot. C, a trespasser has been using an owner's property for a certain period with the owner's knowledge but without permission. Or D, a property owner wants to prevent the owner of an adjoining property from building a or an improvement that blocks their view. Okay, we just reviewed easement by prescription, and I showed you on the Google search. So hopefully you remember, or you were here. I'll say one word: adverse. Okay, Miss Sylvia has typed C. Anyone else? Come on, there are at least 9 of you on here. And all of you are watching now on, Lisbeth must have gotten home, on YouTube. And thank you for the thumbs up. And those who haven't given me a thumbs up, hey, send me a thumbs up. Let me know that you're learning from this. And if you don't, hey, don't do a thumbs up. Just leave it at that. But I would appreciate a thumbs up for all of you that are here. Okay, so far we've got C, C, C. Come on, more of you participate. Come on, this is the time to do it. If for some reason you get it incorrect, we'll discuss it. You're going to say, well, how do I discuss it? Well, you'll type in the chat, right? And I'll research it or give you the answer on the book or give you my own personal answer. Yes, the answer is C. A trespasser has been using an owner's property for a certain period with the owner's knowledge, but without permission. Okay, so that person can actually take over that property, right? Because it's adverse use of the property. So the person is claiming that piece of property. So a court grants that easement. So it becomes a permanent easement because that person has been using it for how long? For at least 10 years, continuously, exclusively, and notoriously, to where everyone could see it, and against the owner's will or against the owner's knowledge. So that becomes adverse possession. It becomes adverse possession, right, of the easement. All right, 300, Lorna. Okay, well, oh, Sophia, thank you so much. Look at that. Thank you for your time. I am learning a lot. Thank you. You made my night. I greatly appreciate that. because of course I don't know unless you all tell me, but I've heard it. However, it's nice to hear it again and from those of you that participate, because my goal is to help you understand it so that you pass that exam wherever you're located. Okay, number 2.7. The purpose of a deed restriction, okay, a deed restriction is to enable an owner to specify A, the form of ownership in which a property may be held, B, how long a property must be owned before it can be legally transferred, C, what groups of people are legally excluded from future ownership of a property, or D, how a property may be used and what improvements may be built on it. So what is the purpose of a deed restriction? So remember, you have zoning restrictions. So that zoning restrictions is within the city, and then there's zoning restrictions out in the county for land. So the zoning restrictions is one of the police powers, right? So it depends on what type of zone it is. However, that's one of the police powers. That's by the city or the county. This is a deed restriction, okay? Not a zoning. So what does that mean? All right, I've got D. Whoa, you all are doing awesome. Yes, the answer is D. How a property may be used and what improvements may be built on it. So let's say, for example, you've got a community area that has, $1 million homes. Are they going to want you to go in there and take a manufactured home? Heck no. Right? What'll that do to the other property values? Right? It'll decrease the values of the other properties and mess up the aesthetics, unless it's a $1 million manufactured home. However, manufactured home is still a manufactured home. So therefore, they're going to put restrictions on that deed that are tighter than the city zoning and say, hey, we only want 5,000 square foot homes, 2 stories, 3-car garage, completely fenced. We want them to be brick or stucco, right? No hardy plank, no wood, no pier and beams, and concrete sidewalks. Okay. So then anyone who buys a lot there, they have to follow those restrictions, those conditions. We refer to them as CCRs. We don't hear that a lot, but it's conditions, covenants, and restrictions. And those go with the deed. So it'll be mentioned in the deed and then described in the bylaws or the articles of that HOA or that subdivision. So very good. How a property may be used and what improvements may be built on it. If there aren't any deed restrictions, that means, they might be out in the county and they can put anything in it. Within a city or within a subdivision, in addition to the zoning, because these builders, developers, they have to meet the city zoning to begin with. So these are tighter restrictions. All right. And then they'll have an HOA, homeowners association, in order to enforce those restrictions. One the secretary, and whoever else they may need. Okay, number 2.8. Melinda purchases a house and finances it. Okay, purchases a house and finances it. Keyword. The lender in turn places a lien on Melinda's title. the lien in this mortgage transaction is what? A, evidence of debt incurred by a property owner. B, a promissory note granted by a property owner as security for a debt. C, the creditor's claim against the property as collateral security for the loan. Or D, the document required to clear clouded title. So what is the finances, okay, places a lien on Melinda's title. So the lien in this mortgage, or it could be a deed of trust in some states, right? And a deed of trust has how many parties involved? 3. A mortgage is just the lender. So let's see, we've got so far C. Anybody else? So is it evidence of a debt incurred, a promissory note granted, the creditor's claim against the property as collateral, or the document required to clear clouded title? All of you are on a roll. Yes. Hi, Lequian. Thanks for joining us tonight. And yes, we are doing national questions. Oh, wow. I lost internet there for a moment. Got an alert. So the answer is C, the creditor's claim against the property as collateral security for the loan. And so that's to make sure for the lender that they're going to get paid. Should they not get paid, then they'll provide a notice to the borrower, mortgagor, right? And if still not paid, then they'll start the foreclosure process. So depending on what kind of loan it is, a mortgage or a deed of trust, then it'll either be a non-judicial foreclosure or a judicial. So mortgage, judicial. Deed of trust, non-judicial. So when there's a deed of trust, you don't need to get a court to get the judge approval. When there's a mortgage, you've got to go to court and get approval to sell it, foreclose it. So mortgage, judicial. Deed of trust, non-judicial. Okay, very good. Y'all did awesome there. Okay, number 9. In a lien theory state, what kind of interest does a mortgage lender have in the liened property? A possessory interest. B, a tenancy by mortgagee interest. C, a legal interest in the pro rata share of the property. Or D, an equitable interest. So this is a lien theory state. There's lien theory and title theory. So what kind of interest does a mortgage lender have in the lien property in a lien theory state? So far we've got D. And D, and D, and D. Awesome. Yes, it is an equitable interest. So the lender has control of that title, right? Equitable interest on that property. That's on the lien theory state. Texas is a title theory state, so the trustee keeps the title. In the lien theory state, the borrower, okay, has the title. Okay, number 10. Did I type the answer? No. So we'll go to number 10 in just one moment. Okay, 2.9D, an equitable interest. So, hold on. Typing something over here. So let me see what the answer says on number 9. The lender generally has an equitable interest. The lender, who is the bank, right? Or the lender, whichever, could be a hard money lender, but not legal ownership. The exception is a mortgage lien on a property in a theory state. Okay. In these, in a title theory state. In these states, the mortgage transaction conveys legal title to the lender, who holds it until the mortgage obligations are satisfied. Okay, so that's like in Texas. We're a title theory state. And some of you, of course, are in other states. And there are, I don't know, I think 30 deed of trust states, and maybe, maybe 50-50 split between lien theory states and title theory states. I don't know the exact number. It's just there are a certain percentage of states that use mortgages and others that use deed of trust. So you want to know that in your state, what kind of mortgage is issued? Is it a deed of trust, or is it a mortgage? Is it a non-judicial foreclosure, or is it a foreclosure? A judicial or non-judicial? Those are the two types of foreclosures. And are you a theory or a lien title state? Okay, number 10. How is a lien terminated? So what is a lien? Type in the chat, what is a lien? What is a lien? Yes, it's related to money. It's a mortgage, right? It's a loan that's attached to the property. So how is a lien terminated? So that lien that's attached to the property, how would you terminate that if it's a mortgage or a deed of trust? A, payment of the debt that is the subject of the lien and recording of the satisfaction. So 1, payment and recording. B, transfer of the property that has the lien. C, recording of another lien that is superior. Or D, death of the lienor or lienee. Let's see. Hi, Prashadi. Thank you for joining us. Awesome. Yes, it is A, payment of the debt that is subject of the lien, right? And that lien is going to be on the warranty deed. It's going to be on the deed and also on the promissory note. And then it has to be recorded, right? So it'll be a lien release. So once the debt is paid and it's recorded, the lender provides a release of liens to the borrower, who is the grantor, who is the owner, right? Who had the loan that they were paying on. So many ways to say it. Or the mortgage or, right? So then it says here, if a default occurs, a suit for judgment or foreclosure enforces the lien. These actions force the sale of the property. So if it's a mortgage, it'll be a what? A judicial foreclosure. If it's a deed of trust, it'll be what? A non-judicial foreclosure. because the deed of trust will explain the process that the trustee will take in order to do a foreclosure, right? Sending out notices and whatever the time period is in that particular state, then they follow those instructions of the deed of trust. All right, number 11. A judge rules in favor of the creditor. And who's the creditor? The lender, right? Since we're talking about real estate, in a court proceeding and places a judgment lien against all the debtor's assets. Okay, it could be another creditor, right? Mechanics lien or something, including their real property. So a judge rules in favor of the creditor in a court proceeding and places a judgment lien. So that is attached to the property. It's attached to the lien, to the deed of trust or the mortgage, and on the warranty deed, well, it'll show up in the search of title. So a judgment lien against all the debtor's assets. So not just on that property, but on all the debtor's assets, including their real property. This is an example of what type of a lien. Is it A, voluntary junior lien, B, an involuntary superior lien, C, involuntary specific lien, or D, involuntary general lien? And you see, I went wide, general, because it says that all, against all the debtor's assets. It didn't say just the residence. It didn't say a specific thing. So when it's very broad on all assets, then all of you got it right. It is an involuntary general lien. Because they didn't volunteer to have a lien on all their other personal property or other ownerships. However, when they take a mortgage, that is a voluntary lien, right? But this is involuntary because they're going after everything. Very good. Okay, for most of you that are answering the question, I forgot to mention it. Remember to type the question number in addition to the letter answer so that we all know we're on the same page on the same question. And so that I also know to make sure that we're on the same page. Because when there's internet issues or there are delays, okay, you might be typing an answer for a prior question. So please include the question number and the answer. Very good. All right, number 12. So y'all are doing really good on these topics. Number 12. So this section of the book, come on, come on, come on, show up. So this section of the book, okay, text number 2, right, is talking about encumbrances, which we just did a bunch of questions, liens, title transfer, and recording, plus also leases, okay? All right, number 12. A real estate tax lien, real estate tax, property tax lien, not IRS lien, and a federal income tax lien, a judgment lien, and a mortgage lien are recorded against the property. Which lien will be paid first when the property is sold? They go by priority order. They go by order of priority. So which one would be the most important? That is first, A, real estate tax lien, B, federal income tax lien, C, judgment lien, or D, mortgage lien. And if you're not sure about this, learn about the priority of different types of liens. Okay, so we've got A, B. Prashadi is not B, so try another answer. Take another attempt, I should say. So you answered B, federal income tax lien. No. You know, you've heard of investors buying certain liens at the courthouse. So what kind of liens would you be buying at the courthouse that are against a property? And these are at the county courthouse. It would be A, real estate tax lien. So investors like to buy real estate tax liens, and each state has their own redemption period. And therefore, they can buy those just for the property taxes that are owed and end up getting a really good piece of property residence just because of the taxes that were behind. I mean, it could be, you know, 300,000, 500,000 or greater, and maybe they owed, you know, 20, 40, 50,000 in taxes. Well, that investor is going to make a good piece of money by buying that tax lien, paying the property taxes off at the courthouse, and holding on to it as long as the redemption period specifies in that particular state. And should the borrower, the owner, want that property back, and I know for Texas, they'll have to pay 25% interest the first year and 50% interest the second year on the total amount, plus all other fees, court fees and stuff that were paid. The investor, if it has a home or if it's land, can lease the land or can lease the home. They just can't sell it according to the redemption law in that state. Texas has a 2-year redemption for tax liens. So after the real estate tax lien, okay, would be the mortgagor, the mortgagee, okay? That would be the second one because they're the ones that loan the money. Anything that's left over then gets divided amongst the others, then federal tax lien and then judgment lien. So everybody gets paid whenever that property is going to be sold. It won't be able to be sold until all those are taken care of. Number 13. A lien holder can change the lien priority of a junior lien by agreeing to do what? A, change the date of recording. B, lower the amount of the claim. C, cancel the lien. Or D, subordinate the lien. So a lien holder, so that they're going to be the primary lender, the primary loan. And they can change the lien priority of a junior lien. So that is a lesser loan than the main loan. Very good. Yes, the answer is D. They can subordinate the lien. They cannot change the recording date. They can't lower the amount of the claim, and they can't cancel the lien, right? However, they can change the lien priority of a junior lien by them taking the first ones to file a foreclosure. They can be the primary. Now, whenever there's a foreclosure, right, if it's a third party, somebody else, or it's the main lender, they have first priority. Let's say the junior lien holder is the one that's filing a foreclosure. Well, the first lien holder is not going to want to lose that property, so they will end up paying off the junior lien so that they can take control of that property again. If you follow what I'm talking about. So if you have two loans, you have an 80% loan and a 20% loan. The 80% loan is a large loan. The 20% is lower. So if an individual is defaulting on the second loan, on the 20% loan, that lender can file a foreclosure. Well, the first lender owns 80% of that loan that they sold, right? I mean, that they gave to the borrower. They have a lot to lose. So they will buy out, pay off the second lien holder, take control, and then they'll probably foreclose on that borrower to get the money back from the second loan that they didn't pay up on. So very good. You all did well. Okay, number 13. 14, pardon me, that was 13. Which of the following accurately describe the act of foreclosure? So for anybody that just came on, I think there's some new people that came on from other states maybe. We are doing national questions still, and we're almost done with national, then we'll go to Texas State. So which of the following accurately describes the act of foreclosure? What is foreclosure? When does foreclosure happen? When somebody goes into default. And what is default? When the borrower is not making their monthly payments, right? It goes into default, and the lender then will give them a notice, and if they don't cure it, then they'll start the foreclosure. So which of the following accurately describes the act of foreclosure? A court-ordered acceleration of loan payments. B, the final step in a bankruptcy filing. C, a proceeding to enforce a lien by forcing the sale or transfer of a secured property. Or D, a proceeding to take equitable title to a property that was liened as security for a mortgage loan. So which one accurately described the act of foreclosure? So far, we've got CCC, and yes, the answer is C. A proceeding to enforce a lien by forcing the sale or transfer of a secured property. So of course, they're going to end up sending notices to the borrower prior to the foreclosure, because those are the laws. They have to send notice for providing time to cure it. And if they can't cure it by the deadline provided on the notice, then the foreclosure proceeding starts. So the act of foreclosure takes place. So a proceeding to enforce a lien by forcing the sale or transfer of a secured property. Number 15. So let's see. Prashadi said, what? A court-ordered acceleration of loan payments. No. So it depends, what type of loan is it? Is it a mortgage or is it a deed of trust? Well, it doesn't say here what it just says what accurately describes the act of foreclosure. Okay, then it is a proceeding to enforce a lien. So the lender has to make sure they get their money. And how can they do that? By letting the borrower know that if you don't catch up on your payments, we're going to take the property. We're going to put it up for foreclosure, for sale at the courthouse. So A is specific to a mortgage state, okay, not a deed of trust state. So that's more specific. So this question was more general. It's a proceeding. Excuse me. All right, number 15. A property is secured by a mortgage that does not contain a power of sale clause. So what is a power of sale clause? So secured, what is secured? Mortgage, foreclose, all these are vocabularies, right? And it's important to know all those words, keywords, in order to understand what they're asking for. A property is secured by a mortgage that does not contain a power of sale clause. To enforce, the lien holder will have to do what? A, file a deficiency suit. B, file a foreclosure suit. C, file a suit to quiet title. Or D, obtain a quitclaim deed. So a property is secured by a mortgage that does not contain a power of sale clause. So properties that are conveyed or something have a due on sale clause. So if they convey it, they have to make sure they inform the lender, and the lender may enforce that, right? And accelerate the loan if the property is conveyed without informing the lender. However, they could also convey it to a trust, and that's not necessarily selling the property, it's putting in a trust. All right, so far I've got A, and let's see. Okay, Prashadi, you said 214A, so I hope you mean 215. So it is not A because it's not a deficiency suit. A deficiency suit is when you've already sold it and there's money still owed. So the sale did not bring enough money to pay off the mortgage or the loan, okay, or the deed of trust. It is not to quiet title. The quiet title is to remove any judgments or any things that are like a name change or something like that, so they can use a quitclaim deed. So in order to quiet a title, right, you're removing all types of liens. So a title search showed that, hey, there's some issues with its title. So now we got to quiet the title in order to be able to sell it, to have freehold title, a fee simple title. So it's not that either. So a property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder must have to file a foreclosure suit. B. So how are they going to foreclose? File a foreclosure suit. Okay, so most of you answered B. And 1A, yeah, deficiency, it means, it sold for under the amount that was owed on the property. Therefore, it's not that. This just says there is no power of sale clause on the mortgage or the deed of trust. Therefore, to foreclose it, the lien holder will have to file a foreclosure suit. Yeah, some of these words, yes, can be tricky. That's why it's important to really, really, really learn your vocabulary or memorize it, whichever way will help you know what they're asking, okay? I think if you're doing a vocabulary test, right, by memorizing it, right, you'll remember the vocabulary. And in questions, you've got to also understand what the vocabulary meaning is, so that when it's used in a question like this, then you'll be able to understand it. So if you have questions on some of these words, okay, it's keywords, it's please go and review the vocabulary. I have many, many videos on vocabulary. that you can watch. See, so the power of sale clause, so because you did that. So a power of sale clause in a mortgage note states that the lender has a power to sell the property in the case of a homeowner's default. In other words, it gives your lender the right to sell your home and use the proceeds to pay your outstanding balance if you fail to pay your mortgage. So if it doesn't have a power of sale clause, the only way they can enforce it is to file a foreclosure suit. Okay, what is the power of sale? So that's what power of sale in foreclosure. So let's see, what is the effect of a power of sale clause in a loan document? Power of sale is a mortgage clause that permits the lender to foreclose on and sell a property in default in order to recover the remainder of the loan. This clause, which is legal in many U.S. states, allows for a foreclosure process that circumvents the courts for speedier outcomes. Okay, so a non-judicial foreclosure, like in deed of trust states, will have a power of sale clause, because the deed of trust will have all the description for the trustee to follow on how to do a foreclosure. And in a mortgage state, they're not going to have that. Therefore, they have to go to court. Okay, so that was the last question for national. And before I shift or transfer to state questions, let me know if you have any questions on national. And the author of this book, okay, I love this book, and so do a lot of students, okay, because it explains the answer. So this is the book we're using by Stephen Metling, Cusick, Metling, and Hamilton, and I have permission to use it. And you'll see the answers, okay? They describe the answers in detail. And if you're still not comfortable or understand the answer that it has on here, then I say Google it. And the other thing I want to remind you is, and I added it now to the description, is for those of you that are in Texas, it probably also happens in your particular state. If you're in another state, the Real Estate Commission has a section called Frequently Asked Questions, FAQ, that has lots and lots of questions that you can study from to prepare for the exam. Those are free. You don't have to pay for it, right? It's in the Real Estate Commission. So for Texas, I put a link, the Texas Real Estate Commission, FQA, Frequently Asked Questions. And a couple of my students, said, hey, I studied those questions, and he recommended it on YouTube on one of the videos that he says, hey, go and study the questions that are in the Real Estate Commission, Frequently Asked Questions. So Sophia is in Virginia. Sophia, you probably also have in your state, okay, with your Virginia Real Estate Commission, a section that talks about frequently asked questions. And there'll be questions similar to what you'll have in the exam. I'm not saying they're going to be exact, because it's tough to say exact. The examiners create many sets of questions, and they've got a pool of questions that they end up using for the actual exams. So every exam is different. Prashadi is in Texas. Okay, then go to Texas Real Estate Commission track, and you can access all those commissions. All those questions. Okay. In addition to questions that you use on your prep book or a prep book like this, you can buy this prep book. There's or other prep books. I have several links in the description below that you can purchase from Amazon. Just know that should you use my link to purchase, I will earn a small fee from Amazon for using that link. It doesn't cost you any more. So got it. Thank you. So utilize your Real Estate Commission website, okay, to also search for other information. Okay, so we are moving into Texas. So for those of you from other states, hey, it was awesome having you here. You can stay on and because I point out keywords. So keywords are vocabulary everywhere. Okay, and the vocabulary applies to national and state. And so it's vocabulary in general. In some areas, there's 1,000 vocabulary. In others, a lot of the free material online for vocabulary, some of your prep books might have the vocabulary, some don't. This particular book does not have vocabulary. Other books that I've used do have the vocabulary. In fact, there's a link in the description below for Texas Real Estate Sales Exam 4th edition that's on the internet that has lots of vocabulary, and it is an excellent book to use for national, that you can use for national exam. And for those that are in Texas, just know that a few of the Texas questions are outdated. So let me see if I can show you real quick here when I mention about the links. So in my description below, it's a little delayed here. Oh, wow. Well, somehow my copy and paste, I'll have to include it on there. Anyway, on the description, so let me show you another video, and you'll be able to see it there. So that's my YouTube Agent Prep banner that I created. One of these days, you might have a YouTube channel in order to attract buyers or to educate. Yeah, you can tell the internet's a little slow, but at least it's not like what we had, I think, on Monday that we kept getting cut off. So anyway, go to the description, and I'll update the description tonight after class, and it'll show you. Okay, here we go. Let me point out the book that's free online. It's an old book from 2006 or 2007. And it has excellent national questions. It has vocabulary. It has a review. It has a Scantron. And it also, so when you scroll down on the description, you'll see here, real estate license exam prep books and questions. So the first one is the TREC website. So for those of you in other states, go to your particular real estate commission and look for frequently asked questions. The next one, let me see which one is. I don't have it on here anymore. Well. Oh, yeah, here it is. The third one, Texas Real Estate Sales Exam, 4th edition by Learning Express. It's from 2006. This book is excellent. You can download it by going to that link and use the vocabulary from there. You practice the national questions, and it has a Scantron that you can print out and do all the exams. Plus, it also explains the answers, and then it gives you a summary of the questions that were asked and lets you know what part of the test they belong to. So let's say they're discussing the topic that we're doing today, encumbrances, okay, liens, judgments, leases. So it'll divide all the questions, 110 questions. The first 80 are national, the last 30 are state. It'll divide them according to the topic that it was discussed that applies to the actual exam. So this is the only book that I have seen that does that, and I love it. So Texas Real Estate Sales Exam, 4th edition. You can buy the book, okay, from Amazon. However, hey, it's free on the internet, so you can download it. So any of these that have a link on here, Amazon will pay me a fee. All right, so enough of that. Just wanted to point out where they are, and I'll add it to tonight's link. When I was preparing for it, for some reason, I didn't copy and paste correctly. And so I couldn't show it to you on that one. Okay, bear with me a moment, because now I'm going to shift into state questions. State questions. All right, so let's see. For state questions, we're going to cover now. I think we are dealing with what? Texas Real Estate Commission questions. I thought we had finished that. Today is the 14th. Interesting. I thought we finished Texas Real Estate Commission. Let me see what's after that. 3 years, 4 years. Let's see. I think we did. Let's see. Trust fund documentation must be maintained by a broker. Yeah, we did that one. I'm thinking. Hold on, bear with me. I think it might be question 30. Internet advertising requires disclosure of the advertiser? No. Gosh, does anybody remember what question we left off on Monday? Let me see. Well, according to even the answers, okay, so I guess we'll start with 16. And if we did them already, then hey, you practice again. Okay. So it's repeat, repeat, repeat until you get 100 on each of the questions. All right, so we're starting with, we're starting with number 16. I remember that other question. So if I did 15 questions, it would have been 31 that we would be starting with. Because some of these sound familiar. Well, that's okay. We'll repeat the questions. Because if you missed them on Monday, then this is a practice to get them right. Okay, so number 16 for Texas State questions. Oops, let me share the screen. The Jordans and the Couriers have jointly directed the broker Michael in writing to pay out the earnest money deposit to the courier's son, Stephen, despite the fact that this action is not stated as permitted disbursement in the sales contract. Michael refuses to disburse. Which of the following is correct? A, Michael must disburse the funds as directed. B, Michael must follow the provisions of the sales contract and refuse the directive. C, the principals have made an improper request and the matter must go to the arbitration, or the matter must be remanded to the registry of a court of settlement. So the question says the Jordans and Couriers have jointly directed the brokers. In other words, they both agree. Okay. For the broker to write in writing, okay, they did it in writing, not just verbal, to pay out the earnest money deposit to the courier's son, Stephen, despite the fact that the action is not stated as permitted disbursement in the sales contract. Now, if they do something in writing, then who do we listen to? Right? If the both seller and the buyer agree and it's done in writing, it's almost like an amendment, okay, to the contract. Then which one would it be? A, B, C, or D? Does Michael accept, refuse? They have to go to a court, or it goes to arbitration. Let me see here. Hi, Christopher. Do the course completion certificates expire? Typically not. It depends if you're in Texas, and depends, I guess, how long ago you took it, or if there's been change in laws. So the best answer is to contact Texas Real Estate Commission and find out. So let's see, I have failed the Texas State Part twice by 1 mark. I have only 1 attempt left. So keep repeating the questions over and over. Download that one book that I just showed you on the link in the description. You know, download that. It has lots of excellent state questions, even though a few are outdated. So yeah, I was thinking we finished a test and maybe we were starting with number 14. But no. Oh, you know what? No, last Monday we started with 13.6 and today is 13.16. So no, we're okay. We did finish test number 1 on the national, but on the state, I thought I was seeing 16 twice. All right, so far I've got A. So Christopher, welcome back. So he says, took the courses a couple years ago and just getting back into it. More than likely your certificates are still there, Wu. You could go into your online services account to see if those courses are still there. And quickest way is to also ask TREC. So if they're still listed there, that you sent the certificates of what you've completed, they would show up there on the free account that we have. If not, just call TREC. Yeah, so number 16, the answer is A. Michael must disperse the funds as directed. That is correct. So thank you for your questions. Those are all good questions and comments. So 16A. Okay. Number 17. So if you're watching on YouTube, hey, remember to tap that thumbs up. Send me some love, okay? Let me know that you're supporting my channel. Because, hey, I do this free, and it's hopefully helping you prepare for your exams to pass. All right, number 17. So all you can do is show a little love by tapping that thumbs up button. And I think you could also do some what do they call it? Super chat and super stickers. You might show on the lower right-hand corner a little icon where you can support me with super chat and super stickers by contributing money, donating money to support me. It doesn't show up on mine, but it may show up on yours. So I'm curious if anyone is seeing the little super chat icon on the lower right of your chat box where you post a comment on I saw it on somebody else's website, on somebody else's channel. So I'm curious if you can see that. Okay, number 17. A home seller makes a legitimate written demand for a buyer's earnest money deposit following an undisputed buyer default. Okay, so a home seller makes legitimate written demand. Okay, so it's written and it's legitimate for buyer's earnest money deposit. So they had a contract, there was earnest money at the title company or an attorney that went along with the contract, and they demanded the earnest money. And the buyer defaulted and they did not dispute it. It's undisputed by the buyer. Okay. So keywords: home seller, legitimate written demand for what? The earnest money. Buyer, undisputed. Buyer's default. So they didn't finish buying the property. A, must disburse the funds within 7 days of the demand. B, must disburse the requested funds within 30 days. C, must notify the buyer in advance of an imminent withdrawal from the trust account. Or D, must return all funds less earned commission and marketing costs. So type your answer in the chat. It is not D, Miss Cindy. If they were to return the fund, they'd be returning them to the buyer. And the buyer is in default of the contract, and they did not. It's undisputed. And the seller demanded the money. So the buyer has already been notified. So when the seller sends out a written demand, they're sending it to the title company or whoever the escrow officer is. That escrow officer sends that written demand, mails it to both seller and buyer and waits for a response. The buyer did not dispute it. They did not respond. So they already notified the buyer. So what happens next? The answer is B. They must disburse the requested funds within 30 days. So Cindy, Prashadi, so you changed your answer. Good. So be careful and, read what they're asking for. What are the key words, right? A legitimate written demand. It's in writing. So in order for a buyer or a seller to get their earnest money, they must sign, or they'll sign, a termination of contract and a release of earnest money. So if both parties did not sign the release of earnest money in order to release it, therefore one of them has to ask for provide a written demand. And it's a brief, statement on a page, and provide that to the escrow officer. Okay, whoever's holding the earnest money with the contract. And then the other keywords are undisputed. So the buyer didn't argue about it, didn't say, no, it's not, it should be mine, because they were in what? Default. So the contract specifies what happens when there's a default. However, the title companies are going to require that a release of earnest money be signed by both parties. And if both parties don't sign it, then that's when a written demand is written by one of the parties and mailed to both, and given time to both parties to answer. And in this case, the buyer didn't answer, didn't dispute. So it goes to the seller, because the seller is the one that wrote the demand. So I'm just curious what the answer says here. So as the request is undisputed and legitimate, the broker has 30 days to comply. Moreover, there is no broker entitlement or marketing costs or commission since the transaction collapsed. It fell. Finally, brokers are not obligated to provide advance notice of a withdrawal to a buyer or seller. It's written in the contract. Okay. All right, number 18. Trust funds documentation, trust fund documentation must be maintained by the broker for what period of time? A, 1 year, B, 2 years, C, 3 years, or D, 4 years. So trust fund documentation must be maintained by the broker. Okay, for what period of time? Goes along with how long do we have to maintain our documentation for, or keep our documentation for? And a lot of these answers that have a number that are even or odd, for the most part, the answers have been even numbers. So that would leave you to B or D. So what is it, B or D? How many years in Texas do we have to keep our documentation and a broker, if they have a trust fund, the trust fund documentation? Oh, the answer is D, 4 years. We must keep I put DD. We must keep documentation for 4 years. And here is if for some reason a broker has a trust fund, you know, it could be for a property management. Therefore, they would have trust funds for security deposit. So that must be maintained for 4 years. Yes, 4 years, Prashadi. All right, number 19. It might be a long question. So, yeah. Okay, there we go. Let me see if I can make it a little bit larger. Okay, 19. A buyer and seller have a serious disagreement about the payment for repairing a defective water filtration system in the subject property. The buyer gives up and demands the deposit back. The seller disagrees, claims the buyer has defaulted, and demands the earnest money as liquidated damages, because the contract is going to say if anybody's in default, they get the liquidated damages, right? It's the earnest money. What should the broker do? Because the buyer and seller have a disagreement, so they're not signing the release of earnest money. So it kind of stays in la la land, right? Until somebody demands it. So it says the seller disagrees, claims the buyer has defaulted, and the seller demands the earnest money. But who has the defective water filtration system? A, follow the instructions of the broker's attorney. B, pay the trust money into the registry of a court and let the courts resolve the case or the issue. Or C, submit the dispute to the local board of realtors for arbitration. Or D, conform to the terms of the sales contract. So if they cannot decide, so this is after the broker can't help them out. Okay, so the buyer and seller keep disagreeing. So because of the fact that the seller is demanding the earnest money, they probably did a demand letter, okay, in writing, and they already submitted. We are to assume that they submitted a termination of contract and release of liens, because so the buyer gives up and demands the deposit back. That's their earnest money deposit, because the seller would not repair a defective filtration system. Well, whose responsibility is it when they want to sell? And if the buyer didn't negotiate to say, I will repair it in order to close, then whose responsibility is it? It's a seller's if they want to sell. Therefore, they either follow the broker's attorney's instructions. And so basically they would go get their own attorney, not the broker's attorney. Pay the trust money into the registry of a court and let the courts resolve the issue, because they can't decide on their own, and they couldn't decide through the title company. They couldn't decide with the help of, the brokers. Submit the dispute to the local boards. No, it doesn't go to the local board of realtors for arbitration. the Board of Realtors is basically a neutral party for the multiple listing service to have all our listings on there. And then D, conform to the terms of contract. Well, they're trying to, but it's not working. So the final decision is to pay the trust money into the registry of the court and let the courts resolve the issue. So they're having to go to court in order to resolve this because none of the alternatives worked. So remember, you can resolve it amongst your own. You go with what the contract says, and if both parties don't agree, then you try to do mediation. If that doesn't work, arbitration. If still that doesn't work, and somebody is demanding it, then it goes to the court if no one can decide. Because they can do a demand of earnest money. However, if the seller says, no, it's mine, then both parties answered. One says it's mine, the other one says it's mine. So what's left? Go to court. So the money will be held by the courts until that decision is made by the judge. Here comes the judge. Yes, B, 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 B as in boy, 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 boy. Or boss, 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 which is what you're going to be when you become a realtor. You'll become your own boss, unless you go into a team. Okay, number 20. Because you'll be running your own business. Probably not. Oh, yeah, it worked. Okay, number 20. So did you all understand that prior question? Okay. There's lots of little keywords in there. Serious disagreement about repairing a defective water filtration. Well, the water filtration system belongs to the seller, right? Buyer gives up because seller is not repairing it. Probably after the home inspection, they're having discussions. I want you to pay for it in order for me to continue on with the sale. Seller says, no, I'm not going to repair it. Boop, the buyer has the right to get out of the contract. All right, number 20. A licensee wants to sell a subdivision lot she owns. What does the licensee have to do that is any different from a non-licensee selling a lot? Selling the lot. A, the licensee must provide current market value documentation. B, the licensee may not list the property with her broker. C, the licensee must tell the buyers that she is licensed as soon as they meet one another. Or D, the licensee must disclose her license status in writing before signing any contract. So we've got C, C, and it's not C. Take another attempt. So licensee wants to sell a subdivision lot she owns. What does the licensee have to do that is any different from a non-licensee selling the lot? So we've got C, 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 D. Anybody else? It's not C. So choose another one. And many of these have the word must, must, must. So one of the three must would be the answer. And the correct answer is D. The licensee must disclose her license status in writing. Dang it, I hate that thing. Before signing any contract. So she's selling her own lot. Okay, it's going to have the broker information on it. Even though it's a for sale by owner. Why? Because she is licensed, right? Or if she has just a plain simple for sale by owner sign, then she must disclose her license status. And when they write a contract, it has to be disclosed there also. However, it has to be disclosed prior to writing a contract. In case, she just has a simple for sale by owner sign because she's selling it herself, and it'll attract more people by just having for sale by owner. So the answer is D. And we have Chris De La Rosa, who just came in and says, let me show you, just passed her exam. Let's see here. Hello, I just wanted to come in real quick to tell you thank you. I passed my national exam Friday because of your YouTube videos. Oh, thank you. Actually, you passed because of your preparation and watching videos and studying. And I'm grateful that my videos helped in your preparation, and you remembered and you did what was right when you went to the exam, okay, in order to pass. So it's all because of you. So congratulations, and thank you for sharing and letting us know. I would greatly appreciate a testimonial on YouTube or on the AgentPrep Facebook page. It's our private group. If you're a member on there, Chris, if you could write a little testimonial on there and help encourage other students, that would be greatly appreciated. So everyone, give Chris a congratulations, because you will be next to pass, right? So what happens if you don't disclose? Well, if somebody complains, you could be fined, okay? Could lose your license if somebody complains really bad. So it's important to disclose because you are educated and you took courses and you're licensed. Because if you don't disclose, then you're violating one of our responsibilities as a realtor, one of our obligations. However, it all happens when someone, the important period of what happens if you do or you don't is when somebody complains to the Texas Real Estate Commission or to your broker. So here, congratulations and more congratulations. So I was answering this question. What happens if you don't disclose? Well, just make sure you disclose whenever you're talking to a buyer, right? We always have to disclose. Talking to a buyer or a seller or a prospect. If you don't disclose and nobody complains, well, nobody's going to find out, right? Except for you and the other person. However, you yourself know that you didn't disclose. Okay. Hey, you all, I'm going to call it quits now. My throat has started hurting. And I know Cindy likes to have more state questions because she needs to pass her Texas exam. However, my throat has started hurting, and that's not a good. Okay, you have a question. All right. So read the next question, Cindy, and then I'll read it. Oh, so you already said, I have one question. What is your question? Thank you, Miss Cindy. Good night to all of you also. So if a licensee has to put up his house for sale, does he have to? Yes, you're licensed. You must always disclose. List it with his sponsoring broker. No, you don't have to list it. However, you do have to disclose that you're a realtor to prospects, to buyers. That is mandatory. However, you do not have to list it with your broker. However, depending on what the broker requirements are, if you are allowed to sell 1, 2, or 3 properties of your own personal properties, okay, it has to be your personal property or investment, not someone else's. So if you're selling your own, you might be allowed 1, 2, or 3 properties to sell without paying commission. You'll still pay a transaction fee, okay? And you don't have to list it. However, you are licensed and your license is hanging under your broker. Therefore, it's up to what that brokerage allows. And all brokers, as far as I know, or the majority, okay, allow realtors to buy or sell 1, 2, or 3 properties, okay? And it is, okay, so yeah, you don't have to list it, okay, on the MLS. You can just sell it for sale by owner or put it on the internet, okay? However, you want to sell it and you want to sell it yourself, you don't want to attract buyer agents, then you wouldn't put it on the MLS. You're probably still going to attract buyer agents, right? Because there are many very proactive agents that, drive around or call for sale by owners. I've been doing some cold calling and for sale by owners, and some of them were actually realtors, okay? Or their property expired. Can licensees list it with another broker? No. Okay, you are under your brokerage. Well, let me think about it. I guess you could, if you're not representing yourself, but why would you do that? If you have your own brokerage and because you can have somebody else represent you. A lot of times some brokers want you to have someone else to represent you. So you're kind of conflicting. You're with one broker and you're going to list it with another. I guess ask your broker. Okay, every broker has their own rules, okay, and principles, okay, and that you have to follow. Therefore, the answer would be ask your broker, okay, not me, because every broker is different. So it'll be a discussion with your particular brokerage. Okay, because you're going to have principles and responsibilities, okay, from your own broker. All right, if no further questions, we will call it a night. So this is Lillie Hendy coming to you from San Antonio, Texas with YouTube Agent Prep. This is your first time to my channel. Hey, tap that subscribe button. You know what to do. Click that little bell so you're the first to get notified, and tap that thumbs up and send me some love if you found this, when you find this video useful. If you don't like it, no thumbs down. Don't say anything bad. Keep it positive. Okay, so he said the question was in my license exam. Well, you don't have to list it. You can sell it yourself. However, you do have to disclose. Can you sell it, list it with another brokerage? I guess you could. I would say talk to your own broker first before listing it with someone else. Okay. Because you could actually have someone else sell it and say, hey, I want you to pay me a referral. In fact, that could be a discount on the commission. So let's say, normally you would ask your commission rate is 6% or 10%. And you want somebody else to list it instead of you that has more experience, more knowledge, well-known. So it could be a potential that it could be listed with someone else. And you say, hey, I want you to pay me, give me a lower commission, because I'm also a realtor. Therefore, you could ask for 25% reduction in the commission, or 1 point less or something like that. So it's all negotiable. So that's an interesting question. If it's like you said, if a licensee has to put up their house for sale, do they have to list it with their sponsoring broker? Oh, so now I understand what you're talking about. If it has to be, because you don't have to list it, okay? But does it have to be with your own broker? And is that mandatory? Probably not. I would say ask your own broker, because some brokers may have rules to where you can't. They want to have the listing, okay? But you're the owner of the property. So you should have the right to list it wherever you want because you're the owner of the property. All right, y'all. So thanks for attending. And until next time, have a good night. Love y'all. Bye. Next class is Saturday morning at 10 o'clock.